We spoken to item 1 WBC 652/2018.
We have formally just listed for to be spoken to because somehow it missed. We could not prepare and deliver the order. So we just record the what do you call the hearing today and then pass the orders. It will take us 2 weeks or 3 weeks more time. But Mr. V. Rajkumar, on the counsel for the petitioner, Mr. And Mr. Dinath, senior government advocate, along with Mr. Kalidan and counsel for the government advocate, concluded the certificatory hearing. Order is out.
May it please your lordship. My lordship, I brought to me from item number 25, lordship. Lordship, this matter is settled between the parties, became infructuous, lordship. Item 25.
25.
25.
So we can close it then? Lord, we can close the matter then?
Lordship.
Okay. Mr. R. Sharma, learned counsel for the petitioner, on instructions has submitted that the matter has become infructuous.
Lordship.
So accordingly, he has instructions not to press the matter. And accordingly, the matter stands closed, having been rendered infructuous. Okay. Just check up if there is a stay, that order has to be recalled. No, any? Okay. And this IA is also will be closed?
Lordship.
Okay. IA, connected IA, review of order passed in so RSA, this application stands closed.
Yeah, please, Lordship. Lordship, I'd like to move some for item number 13, Lordship, for adjournment, Lordship. My senior has some personal difficulties, Lordship, so he can attend.
Okay.
The matter may be taken after 3 weeks, Lordship.
On the prayer made by learned counsel for the appellant. No, we'll have it 2 weeks because 3 weeks will be close to the vacations. 2 weeks.
Lordship.
In regard to item 5, your lordship take it on Friday, but I could not go through it.
Okay, item 5. Both sides are represented on the prayer made by Mr. S. Dutta and senior counsel. List again on?
Right.
Okay, item 29. Okay.
Published.
Item 1 for motion.
May it please, your lordship. My lord, I will take your lordships to the MP in order, which your lordship will find at page 50. Lord, I was the mortgagee member, and way back from 1959, mortgage was registered. And thereafter, my lord, they could not pay, and ultimately I had to purchase it. After purchase, my lord, mutation was also done. My lord, those things are not taken into consideration by both the courtmen. My lord, I will take your lordships to regulation 50, my lord, of Assam Land Revenue Regulation. Assam Land Revenue Regulation 50.
Where is the plaint?
My lord, this is the registration, the heading. In plaint, my lord, your lordship will find that pleading at my lord, it starts at page.
You are the
Page
plaintiff. You are the plaintiff.
I'm the plaintiff. Page 18, para 5, my lord.
Yes. In this regulation, what do you have to?
That regulation, my lord, regulation 50, liability of persons succeeding to states to give information to succession. You'll also kindly see D. Every mortgagee obtaining possession of any state of a proprietor or landholder or of any share therein shall within 6 months from the date of taking possession or assumption of charge apply to the Deputy Commissioner of the district on the general registers of which the state is born for registration of his name as such proprietor, landholder, manager or mortgagee, and the nature and extent of the interest in respect of which the application is made. Now, in regard to this, my lord, we have complied with the registration as a mortgagee, my lord, that was registered way back in 1959. Thereafter, my lord, the mutation also was done, which you also will find in para 13, page 21. But it is submitted here that earlier on 31/8/1959.
You're reading where?
Beg your pardon.
You are reading where?
Page 21, paragraph 13. That it is submitted here that earlier on 31/8/1959, the suit land was mortgaged to late Badsha Khan, then alive, by the original pattadar, late Majnoor Ahmed, then alive, by registered mortgage deed number so and so, and since then late Badsha Khan obtaining mutation as a mortgagee, remain in exclusive possession thereof, when the plaintiff decided to construct the cinema hall. Now, those are the things, my lord. Now, it was, so far, regulation 50 is concerned, that is totally complied. And these are not, my lord, accepted by the court, both the courts. And in fact, my lord, still I am in possession. They are threatening my tenant. And the court has gone into the fact that they also subsequently, they purchased from me. My lord, I have purchased from them the June 1981. Now they are coming subsequently saying that we have purchased from us in the November 1981. Well, that is totally fraudulent, my lord, by making all fraudulent transactions there. All these pleading we have made in the plaint as well as in the miscellaneous application. Now, the learned court below thought, my lord, since both the parties are claiming for possession, so it is better to reject it. And that is the only ground it has been rejected. My short prayer would be, my lord, status quo as in today will also suffice, because as we are in possession of the land and our tenants are there.
Where is the order of the trial court?
That your lordship will find that page 44, my lord. Order dated 37/2018. Your lordship will find it page 44. From para 4, my lord, the brief facts have been elaborated. The petitioner contended that the petitioner number 1 is the owner and pattadar of land measuring so and so approximately PP number so and so, with petition numbers 2 and 3 constructed a cinema hall. The aforesaid plot of land has been described in schedule A of the petition. The petitioner stated that the plot of land measuring 2 kata 10 lakhs covered by the number so and so, this is the suit land matter, was originally owned by one Majnoor Ahmed, who obstructed the front edge of the cinema hall The petitioners contended that the husband of petitioner number one was in exclusive possession of the said plot of land as a mortgagee since 1959. And the said plot of land is very much essential for the construction of an additional entry gate to the cinema hall. On 9/11/1981, the husband of the petitioner number one purchased that land and constructed a cycle stand, ticket booking counter, and the gate was constructed by the petitioners. The aforementioned suit land is clearly described in Schedule B of the petition. The petitioner submitted that due to heavy loss in the cinema hall business, the said hall has to be closed down, and the land in Schedule B was renovated and showroom was constructed. The petitioners contended that the opposite party on September 2017 demanded the tenant of the petitioner to vacate the showroom and claimed him to be the owner. After due inquiry, the petitioner came to know that the father of the opposite party executed a sale deed number so and so, claiming to have purchased the suit land from the husband of the petitioner number one on 5/6/1981, when he was not the owner of the suit land, and as he has purchased the suit land only on 9/11/1981. The petitioners contended that there is a fear that the OP may dispose of the suit land to any third party. The opposite party filed written objection denying all the contentions and assertions of the petitioner and submitted the petition number one is not the sole owner of the land measuring so and so, but the other sons and daughters of petition number one, including defendant number one, is also the owner of the said plot of land by right of inheritance. The other plot of land measuring 2 × 10 letter covered by so and so is the land of the opposite party. The OP contended that the cinema hall was constructed in the Schedule A land only and not over Schedule B land. The OP submitted that the late Majnoor Ahmed executed mortgage deed pertaining to the aforesaid plot of land in favor of late Badshah Khan, but failed to redeem the mortgage for which it was foreclosed by late Badshah Khan, and he became the owner of the sale. Late Badshah Khan was.
You have a copy of the Jamabandi of the land?
Beg your pardon?
You have a copy of Jamabandi of the land?
So just 1 minute, I will see to that. Here you see. This is this last one. Should I have one? I can use it.
This deed of 9/11/81 is in whose favor?
That is in our favor.
Mr. Dutta, you have to produce the supporting documents because it's very difficult to read from here and to understand, because you see what has happened here
Well,
in this Jamabandi which you are giving. The page number 3 of this contains the name of Regina Khatun. Against Regina Khatun, the entry is not very clear as to when the mutation was done, and because it says number 3. Number 3, the mutation of number 3 is not reflected in this page 3. Then again, this Rija Khatun name also appears in the handwritten Jamabandi. In this Jamabandi, he is number 4. And the land here is 4 bigha, 1 kata 5 desa. The Regina's name came in a mutation order which is made for the year 1959-1960. And you say that you have purchased the land.
Yes, 1981.
So there cannot be a mutation order of 1959-60.
That was, mortgage was registered in 1959. And then I have purchased it in the year November 1981.
Please produce the documents in support of your. Because the Nazari of this Regina Khatun is not there in page 3. Her name is entered. I may be making a mistake. Please look at this and just point out the entry. Because the case of the respondents, as recorded by the trial court, is that the persons who had purchased were not, their names were not even entered in the Jamabandi at that time.
Well, let's do one thing. Let us take the updated papers. And your lordship give us a very short time so that we can get
Take it up, if you want, we can take it up on Friday or Monday, whatever you want.
Monday, my lord, I'll be out of station.
Friday we can take it up.
4th or 5th June. I'll be back on 3rd.
5th. 5th then?
5th will be better for me.
Okay. Is this recording on your prayer adjourning the matter?
Yes.
Okay. On the prayer made by Mr. Datta and Senior Counsel, assisted by Mr. Datta and Counsel to the petitioner. Petitioners, this song, 5/6/2026. We need to know 2 things. Number 1, and the finding, if any, in the order regarding your possession.
Well,
The appellate court makes a mention that you are in possession, but it says that your possession is a permissive possession and therefore is
permissive
not
position.
protected.
According to the,
So in the trial court, how this possession is recorded in your name? So there is any finding with regard to the possession?
yes.
Because in this case, perhaps due to the registration of the sale deed, you are not asking for title. You are asking only for the cancellation of the other deed.
Right.
So that also leads to another point as to whether in this case, you could have sought for any other relief and not taken that. And the specific relief act, you'll have to have a complete relief. Because there is a title deed of someone.
Lord, we have challenged also their title. Well, that
Their sale deed has
for
been
setting
challenged.
aside, that also, that prayer is also there.
That's why, if there's a document in your favor, then you can definitely consider.
Anyway, obliged.
Item 2 or motion.
none appears on call for the petitioner. Next one. Petitioner was absent when the matter was previously called on 20/5/2026. So accordingly, it appears that the petitioner is not interested to pursue this petition, and accordingly, the matter is dismissed for non-prosecution.
Item 3 for motion.
My lord, here in this case, my evidence, cross-examination was expunged, my lord. Due to non-appearance.
How many adjournments did you take in course of hearing?
In course of hearing, my lord, actually the matter has been referred to the commissioner, my lord. Statement I have given at paragraph 4.
Paragraph 4.
Paragraph 4 can be seen, my lord. So one chance may be allowed, my lord.
But this is very vague. You are unable to understand how many adjournments you took.
Adjournment as such, my lord, I have actually on that day.
No, you see, in paragraph 5, you make a statement
Yes,
that for various reasons, cross-examination was not done on the prayer made by the petitioner.
yes,
So on various dates, things more than 3,
it is before the commissioner, my lord.
whatever be.
Yeah.
Date fix may not be in the court.
It is more
because
than 3, my lord.
then statement is not there, then why should we interfere?
There was counterclaim also, my lord.
And being a disclosure as to how many adjournments you took. Mr. S. Ghosh, counsel for the petitioner is present. As there is no clarity as to the dates on which adjournment were taken either before the court or before the advocate commissioner. So the petitioner shall file an affidavit to disclose the number of adjournments that they have taken as they have taken during the at this stage of hearing. Next for this strong.
By Monday, I have done.
This strong. 6/6/2026 for the affidavit. Maybe filed, but with 1 day prior to the limited to listing.
Item 4 or motion.
That is question. Impel order is page 38. This is in a land grabbing case filed against me by a person who has no title over the land. Status quo has been granted. This is the fishery. Page 38 is the impel order. Petitioner is represented. Today is the date fixed for order. The result of the case record reveals that the petitioner filed this petition for injunction under section 9(10) of LG Act, reduced section 151 of the CPC. It is contended that in the said petition, that the petitioner gave license fee to the estate manager of Sultanity Estate on 4/1/1974. An allotment was issued in the name of the father of the petitioner on 4/8/1977 by Government of Assam, and as such, the petitioner has been enjoying the scheduled mentioned land. But in the year 2015, the respondents left the land of the petitioner. It is further contended that the respondents are changing the natural feature of the land by making therein a fishery. The respondents are now a owner of the said land and the allotment. In view of the above contention, the petitioner has prayed before this court to grant injunction as per section 9(10) of LG Act, reading section 151 CPC. From the discussion as made above, both the parties are directed to maintain status quo over the land in question until further order from today. Lordship, section 9, but before that, going to the provincial lordship, may I please take a lordship page 35. A report was called for from the settlement officer, that's the assistant settlement officer, page 35.
Yes.
Page 35 is the report, second paragraph, lordship. It is addressed to the honorable court. As per availability of third arrest draft plan record, it is found that an area measuring 10 katas in second arrest dark number 137 of 8 vigor, 10 katas in second arrest dark number 138, total area 9 vigor of land mentioned in above Mauja Pargana had been allotted to one Jamuna Mui Sarkar, our grandmother, daughter of late Radha Mohan Sarkar, by allotment slip number 22064, book number 221, and after death of original allottee, her inheritance, namely Ramballabh Sarkar, Babul Sarkar, Ramkishore Sarkar, son of late Ramapada Sarkar, has been recorded and updated in third arrest draft land record by virtue of inheritance by conversion order dated 17/10/2015, passed by the Ayasa Sadar by conversion case number 57 of 2015. Therefore, such allotted land in question has been converted into third arrest periodic pattern number 3. These 3 persons are the petitioners before your lordship. And despite this, this is on record, the ordered impel order has been passed. And once CW1 was also examined, who has approved these documents. Page 33 is the 33 is the this deposition of CW1, who is an officials of the settlement office.
Page number
Page 33.
33.
33. An except for. in section 9 of this Land Grabbing Act, it says that provisions of civil procedure is applicable.
That we are aware.
So order 39 will be applicable. So in any case, the three golden principle has to be examined, looked into, but it has not been done. We have not been heard also, and this order has been passed only on the contention of the applicant. So my humble prayer, Lordship, this impugn order may be stayed and notice may be issued. This is a fishery, now rainy season, fish is going out, so.
You did not contest the proceedings?
These proceedings, Lordship, Miss Case, were not aware of.
How can that happen?
Yes, that question came into my mind also. Main case was, we are referring, we filed written statement also in the main case. And in the order also does not reflect that we are not,
If you don't contest the proceedings, your presence will never be recorded. But then you have not filed any, you have not filed any pleadings. How should we interfere?
but even in Lordship, as per the materials on record, there are four of the petition I have made this statement. The notice of the state petition was served upon the petitioners. And as such, although the petitioner's counsel were appearing in the main case, he did not have any knowledge of the injunction petition. It appears from the impugn order, just it was prayed for, it has been allowed. But there was record, court has called for the report, court has examined CW1.
But you don't contest it. Makes it an admission.
So we have made statement lawsuit that we did not receive notice of this petition. At page 17, notice of the LG case is there, along with this complaint. There is no mention of this, any mistake also.
But you're not producing this order sheets. We don't know what has happened. The notice was sent or not, you're not producing those orders.
The notice of the LG case does not say lawsuit that there is a mistake.
That's your statement, but why don't you produce the copy of the order of the trial court? And no notice was issued. And this proceeding, what you call this land grabbing case, this was registered in 22.
Yes.
And this case also was registered in 22.
That is true.
So for 22 to 26, 4 years, you can't say that you are not aware.
But even materials on record lawsuit. Record is
That's only one part.
to
The second
examine.
part is that the court has issued a direction to maintain status quo. How does it interfere with your activities in the land if you are in possession? You cannot, by status quo, it will only mean that you cannot raise any new construction.
No, this is a fishery lawsuit. It is admitted that there is a fishery.
No, but if there is a status quo, how does it affect you?
Because I cannot fish also.
No, there's no prohibition. Status quo in a house will not make that the house cannot be inhabited. If you're doing an agriculture, it doesn't say that you don't do that agriculture.
So that observation is given lawsuit or
No, but why should we give a clarification? Unless you are restrained by somebody not to
Then they will file violation case lawsuit, there will be a big problem.
You are presuming that. Can by way of an injunction, somebody so that it's a violation of the status quo. Any decision on the point that status quo would also mean not to clear the, not to harvest the paddy. Any decision by any authority, any court, including Supreme Court, which says that by status quo you don't, you're out of possession or you
As
can't
it is
do
in
that.
position, its nature cannot be changed. There are, if it is paddy field, it cannot be harvested.
No, but harvesting, you see, there must be some authority. This is not the first time that agriculture right or physical land has been made subject to status quo. Somebody would have decided by now that status quo would mean not even to harvest the paddy or to make the to catch fish in the pisciculture. It's a perishable item. Some authority must have decided by now. In the country, there should have been other lands which have been attached.
Only permission is sought for, leave is sought for to harvest.
If it is there, you don't suffer any injury. Did you produce the order sheets showing that how this matter was dealt with?
Okay, I'll produce.
Mr. S.D. Progressive Counsel for the petitioner submits that although the notice of LG case number 14 of 2022 was served and the petitioner appeared and contested the proceedings before the learned additional sessions judge within bracket FTC bracket close Kachar, Silchar, but no notice of the proceedings of Miss Case number 11 of 2022 was ever served. And pendency of the said case was not brought to the notice of the petitioner, for which the petitioner could not file any objection to the said application. Next, accordingly, as the order sheet of the said, in this case, number 11 of 2020 is not available from the legal counsel of the petitioner pays for some time to obtain the same and to produce before the court. List on.
Then, 12, so 12, 2 weeks.
12/6.
12, because certified copy has to be obtained, and then I have to file additional affidavit. Or 10, 10.
10, 6, 20, and 6.
Okay.
Item 6 for motion.
Yes, Mr. Sheikh.
May it please your lordship. My lord, by impugned order, my lord, limitation was condemned for 177 days. So, my lord, my only question before your lordship, that actually the case proceeded ex parte against the defendant from
Day before
17/11,
yesterday, day before
2021.
yesterday, I condoned a delay of 2,900 days.
But that is there, my lord. But that is the principle, my lord, if sufficient cause is given.
The last
My
earlier record of this bench in condoning the delay was 2,700 days.
My lord. My lord,
That was-
law is this, my lord, that short delay may not be condoned by your lordship, but on the other hand, long delay may be condoned by your lordship if
But
sufficient
120
cause and
days,
satisfaction of the court has come. Now, my lord, my humble submission before your lordship, that the suit proceeded ex parte on 17/11/2021.
11/21.
Page 32, my lord, of my petition.
Yes.
Now, what happened, my lord? They calculated delay from the date of ex parte decree. So, my lord, my humble submission before your lordship, that delay is to be calculated from 17/11/2021, not from the date of decree. Because, my lord, that ex parte order is not interfered with by the court.
That is at page number
That is at page 32, my lord.
32. Okay.
My lord,
And where is the ex parte decree?
33, my lord.
33.
33, my lord. Order dated 17/11/2021. 33. Plaintiff is represented defendant.
No, the decree is passed on which date?
Decree, my lord.
Ex parte
Decree was
decree
passed.
Was passed when?
Fifteen 2024. Page 30, my lord.
Page
Page 30.
30.
30. It starts from 30, continue.
Yes.
So, my lord, your lordship will turn to page 33.
Yes.
Order dated 17/11/2021. Plaintiff represented defendant is absent without any step. As such, suit will proceed ex parte. So, my lord, that ex parte order is in existence as on today, because it is not interfered with by the court. And what happened, my lord, from the date of decree, that is from 15/6/2024, only limitation petition was filed to condone the delay from 15/6/2024. Now, my lord, my humble submission before your lordship, that only delay from 15/6/2024, if explained, my lord, that will be sufficient to admit the appeal. And regarding this ex parte proceeding, that is not mentioned in the Mijay case, my lord. That is not mentioned in the limitation petition. Petition for condonation of delay. That is to be explained, and that has been suppressed. That case is proceeding ex parte from 21 November.
Okay. Mr. M.A. Sheikh, learned counsel for the petitioner. By filing this application under Article 226 of the Constitution of India, the petitioner has assailed. Now, the petitioner, who is the plaintiff decree holder in title suit number 91 of 2015, which was decreed starting on 15/6/2024, has assailed the order dated 9/3/2026, asked by the learned civil judge within bracket senior division bracket close Mangal Darang, Mangalday in
One 102, my lord, case. Title appeal number 2/2025. 102, my lord.
in title appeal number 2 of 2025, thereby allowing the prayer for condonation of delay of 177 days beyond the period of limitation for which prayer was made by petition number 75/25. Next paragraph. The learned counsel for the petitioner has referred to the documents annexed to this application. And it is submitted that the learned trial court had passed an order dated 17/11/2021,
Page 33.
directing the suit to proceed ex parte against the respondents, against the respondent, public defendant number 1. Stop. However, the suit was decreed ex parte on 15/6/2024. Next, it is submitted that the respondent had not explained the delays which had occurred on and from 17/11/2021 till the ex parte decree was passed on 15/6/2024. So accordingly, from it is submitted that the delay of 177 days alone could not have been condoned without any explanation for the delay of almost 2.5 years from 17/11/21 to 15/6/2024. It is also submitted that in the state petition number 75/25, which was filed under section 5 of the Limitation Act, there was total suppression of material facts regarding the delay which had occurred between 17/11/2021 to 15/6/2024. Accordingly, it is submitted that the impugn order dated 9/3/2026 suffers from illegality and therefore is liable to be interfered with. Next para. Consider the submissions as well as the materials available on record. Next paragraph. The submission of the learned counsel for the petitioner would have been good if an application was made by the respondent for setting aside the ex parte decree before the court which had passed the decree. In this case, the respondent, instead of applying for setting aside the ex parte decree and order 9/13 of the CPC, has preferred a title appeal, which is essentially an appeal under section 96 of the CPC, read with order 41 rule 1 of the CPC. Under such circumstances, the prescription of delay would be covered by Article 116 of the Schedule to the Limitation Act, which prescribes the period of limitation of 30 days for filing an appeal under the CPC to any court, to any court other than the High Court from any decree or order, and the period of limitation would run from the date of the decree or order. Therefore, the respondent was not required by the prescription of Article 116 of the Schedule to the Limitation Act to explain the delay which had occurred on and from 17/11/2021, the date when the trial court directed the suit to proceed ex parte, till 15/6/2024, when the ex parte decree was passed. Therefore, the contention of the learned counsel for the petitioner is recorded only to reject the same. Next paragraph. Insofar as the delay of 177 days is concerned, comma, the respondent has explained the causes of delay by stating that as that he is a senior citizen and illiterate person, and he was under a bona fide impression that his learned counsel would inform him whenever the case would be disposed. And as he had no knowledge of the ex parte decree, he applied for the decree, and by the time the application was filed, there was a delay of 177 days. Next, in this case, as the learned trial court, the learned first appellate court, i.e. the court of learned civil judge in bracket senior division, that it was Dharan Mangalai, had exercised his discretion to condone the delay by examining the materials placed before it, this court in exercise of superintending jurisdiction under Article 227 of the Constitution of India would not interfere with the exercise of discretion by the learned first appellate court, as it is a matter of subjective satisfaction of the courts to condone the delay and in this case, the learned first appellate court had arrived at a finding that had formed an opinion that the procedural laws of limitation are meant to ensure diligence, but not to defeat substantive justice. And accordingly, preferred that the courts would determine the matter of merit instead of shutting the doors of justice on technical grounds of limitation. This court does not find this said reasoning to be perverse or shocking to the conscience of the court. Next, accordingly, the court is disinclined to interfere with the impugn order dated 9/3/2026, passed by the learned civil judge within bracket senior division bracket close Dharan, Mangalai, in title appeal number 2 of 2025, in allowing petition number 75/25 and to condone the delay of 177 days. Accordingly, this application fails and the same is dismissed. Next, the issue shall transmit a copy of the order to the learned civil judge within bracket senior division bracket close Dharan, Mangalai, to make it a part of record.
Right.
Item 7. Heard.
May I bring motion?
Ms. M. Dev, done counsel for the petitioner. Next paragraph. this, by filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 6/1/2026, passed by the learned civil judge within the senior division, coast Dhubri, in PS 34 of 2020, by which the evidence of the PWs were expunged and the evidence of the plaintiffs of the petitioner plaintiff's side was closed. Next para, it is projected in this application that the husband of the petitioner,
Petition number 2, Lord.
petitioner number 2, was suffering from cancer since January 2024 and hospitalized at Gauhati Medical College and Hospital in June 2024. And though the matter was informed to the learned counsel, and the same was informed to the learned counsel of the petitioners to stop. It is further projected that the husband of respondent number 2 had expired in the meantime on 25/2/2026, and only thereafter the petitioners could know about the order impugned hearing. Next, accordingly, issue notice returnable on, so give a date, return responsible. Petitioners shall take steps within 2 days for service of notice on the respondent numbers 1 and 2 by speed post with AD. So the learned counsel of the petitioner shall collect the postal receipt number and submit postal track report prior to the exit of the state. Next paragraph.
3 and 4, I am missing.
For 3 and 4, okay. And Ms. Lidas Verma and additional senior government advocate accepts notice on behalf of respondent numbers 3 and 4. To stop, requisite extra copies of this application will be provided to her within 2 days. Next paragraph, till the next date of the stay, further proceedings of title suit number 34 of 2020, pending before the Court of Learned Civil Judge within senior division shall remain state.
Public.
17th of July. For orders, item 14.
May it please your lordship. Your lordship, in this matter, as per last order dated 1/4/2026, the other side took time to bring instructions, my lord, as regards to withdrawal of their wakalatama.
After filing of this I-2391/2023, I immediately wrote a letter to the respondent number 1 and 2. But the postal receipt is also there. But this letter was not delivered. It returned back. So addressee not found.
You'll have to continue, we can't help it.
Lordship, that is the situation. Until and unless I serve the copy. So I may be disposed of, Lordship, and matter may be fixed for hearing. In the IA, Lordship, while order dated 23/2023, a order of status quo was granted. They have alleged that we have entered into the suit premises and carried on some construction.
You have not filed any objection?
Lordship. Yeah, they filed the IA, but I could not contact the respondent number 1 and 2, so therefore I could not find.
Your name?
S. E. Murtaja, on behalf of Ms. R. Chaudhary.
S. E. Murtaza, learned counsel appearing on behalf of Mrs. R. Chaudhary, learned counsel for the learned senior counsel for the applicant. Also heard Ms. Agni Chaudhary, learned counsel for the respondent numbers 1 and 2. Next para. At the outset, the learned counsel for respondent numbers 1 and 2 has submitted that after filing of this interlocutory application, he had sought for instructions by sending a notice by registered post with ED, but he's yet to receive instructions. And accordingly submits that and no objection could be filed in the matter. Next para. This is an application, the order 39, rule 1 and 2, read with section 151 of the CPC, by which the applicants were the substituted appellant number 1 have paid for ad interim injunction appellant number 1B to 1C. Not substituted appellants. It will be appellant numbers 1B to 1C. Applied for ad interim injunction to restrain the respondents, the respondent numbers 1 and 2 of the plaintiffs, of the men, employees or other persons claiming under them from releasing construction over the land described in the schedule to the application
You can't give you relief. You have a copy of the brief with you? No.
They
You
have
have,
prayed for recovery of possession also.
you know, you have a copy of the application, the memo appeal.
Demo appeal.
It's 35,
Yes,
35
35.
appeal.
Yes, sir.
Wait to have.
Prayed for recovery. Prayed for recovery
No,
of.
no, I have not on there. You seen this? Now you juxtapose this with page 11 of your interlocutory application. Now in the suit, your prayer is the schedule of land is Pargona Igara Sati Moza Simanta Kanchil, popularly known as Borbak settlement. In your application, you have said Pargana Kusiyarkul. Moza is Botorashi. Now here the dark number is 2261 old 2137 new. Here it is old dark 2261 new dark 2237. It will change. Then west is the residence of the applicants. In the suit, it is courtyard of the principal defendant number 1 and then his house. North is Moti Mia, here it was Martin Mia. South Anwara Khanam. South is Bachai Mia. So everything is changed. This is what is providence. You believe in providence. This is what is providence. You don't get a relief. Difference in schedule. You just don't this is what a present. Or how this should be there, you can have an objection in there. If you say that as there appears to be an alteration, what do you call it, as the schedule made in the plaint, which is appended as at page 35 of the memo appeal, is found not corresponding to the schedule of the land at page 11 of this application, or the matter stands adjourned to enable the petitioner to for the petitioner to take instructions in the matter. Next, in the meantime, as the appeal is ready for hearing, this being an appeal of 2014, and is the matter for hearing on.
Item 15.
Made. Yes,
Madam. As per office note dated 27/4/2026, Madam,
Service of notice in respect of respondent number 1A and 1C. Address cannot be located. And respondent number 2 service is complete, my lord. I will take fresh system, my lord, after collecting proper address,
No, you have to bring on record, only then you can take steps.
my lord.
But you are not taking usual steps. Why?
So direction 24/5/2023, Act taken statement 17/7/2023, madam. 17/7/2023.
17/7/2020.
3.
So that is, it says no user process has not been received by the section. And this addressee cannot be located is continuing for a long time. And this notice we don't expect to be served for next 2-3 years. You know why we are making that statement? No. Because this respondent numbers 1A and 1C are ladies, female.
My lord.
They would have married and gone to their
Yes,
husband's home.
Yes, yes.
If you start sending notice to the father's address, it will never be served in the,
Yes, yes.
at least in the near future.
This is I am submitting, my lord. I will correct proper address, my lord.
From 20, this is continuing since 2021. And had I not spent some time here looking at the all this, the matter would have been routinely adjourned. Then एक other than counsel for the appellant waits for some time to bring on record the correct address of the respondent numbers 1A to 1C. As this is an old pending matter, the necessary steps shall be taken within a period of 2 weeks. Next for a list on, give a date after 2 weeks. And you know, in these cases, if you don't read the CPC, again fundamentals of how to serve notice, order 5, you will never in your lifetime be able to do it. Lifetime is, not lifetime is a wrong word. In near future, you will not be able to do it. If she is a married woman, you could have said that these people are there in the family to receive notice on the behalf of A and C, and the brother or others can receive it. Those things you don't take steps because you don't read that CPC.
I will correct, my lord.
Next. I'll take a break and come back.
Yeah, lordship, service complete, and you are receiving the lordship, fixed for lordship hearing. Your lordship.
I am for 1 and 2.
Office note. Dated 6/3/2025, stating that the notice has been served on respondent number 4, which was received by one R. Sultana. So accordingly, notice is deemed to be duly served. None appears for respondent number. Respondent 3, 4, 5, 7, and 8. Mr. The name of respondent number 6 has already been struck off. Right, order dated 10/3/2023. Next, Ms.
Fever.
P. Barba, Learned Counsel appears for respondent numbers 1 and 2. Next, the case is ready for hearing. List the matter for hearing. Give it after vacation.
21/7.
Item 17 for orders.
In this case, I'm mapping for respondent. I have instruction that sole respondent died on 8/1/2023.
8/1/23.
Further, most probably one of the appellants also died, Eunice Mia. Probably. Huh?
Then the appeal will abate. This appeal has abated already. We'll have to close it as abated.
Well, my lord, out of can my lord give us some time to
No, you have already got 4 years' time. It is recorded in the order dated 5/9/2022 that the learned counsel for the appellant submits that he has been informed that appellant numbers 1 and 2 had expired, and he requires some time to take appropriate steps. Therefore, there's nothing to show that the decree which is passed
They have not taken any steps.
can be divisible otherwise, because you are the defendants.
We were the defendants here.
You are the defendant and the suit was for declaration of right title and interest. Before, you'll have to show that respondent number 3 has an independent or divisible right to continue to defend.
If he has a, I mean, we need to substitute 1 and 2 also, but 3 also has a right because the matter is regarding whether our father had sold a piece of land to my sister-in-law, because this issue is between sister-in-law and the other remaining brother. So, Lordship, of course, he will also have an independent right because his interest is.
You can only have a right of partition if that way, so even if you can, you see,
So, my lord,
it is the sale deed of, your father,
Yes.
correct? Now your father is represented also by 1 and 2. If they
Also by
expire and
1
it's abated, you did not take steps for so long, so if it is abated, how can you save it?
My lord will give us one last opportunity. Actually, it has also, it has come up after a long time.
No.
It also.
After 22, it came in again in 18/11/22, and you prayed for 2 weeks' time, it was granted. Now, the sole respondent has also died. 8/1/2023. Mr.
My lord, I'm M.K. Chaudhary.
M.K. Chaudhary, learned counsel for the appellant. Appellants, again, pray for some time. It is noticed that this court by order dated 5/9/2023 had 2022 had recorded the submission made on behalf of the appellants that the appellant number 1 and 2 had expired. Next paragraph. Mr. M. Sharma and counsel appearing for the sole respondent has submitted that as per instructions received by him, the sole respondent had died on 8/1/2023. So accordingly, the learned counsel for the respondent dash plaintiff, no, oblique plaintiff, discharges duty under order 22 rule 10 A of the CPC. So stop for enjoined justice, the matter stands adjourned today. List again on, give a date after 2 weeks.
If you wish.
Item 18.
May it please your lordship. In this case, lordship service already complete and LCR also received. Matter is ready for hearing. 2018 matter, if your lordship gives a fixed date.
Okay, here. Okay, both sides are represented. As the case is ready as regards service. And the TCR is received from, this is the matter for hearing on due date after vacation.
Yes, correct. Yes.
In the start of July.
23rd March of April.
Item 19 for orders.
Open the lawsuit balance, this case balance. And you have application for substitution. There's also condition and also abated ballot. But here, response number 5 and response number 8 expired ballot. So 5%, unfortunately, this is not neither the reflected ballot.
Your applications are not here.
Yes, it's not reflected, but it was filed on 29/3/26 ballot. That's for some time may be given by the, with the up to date.
It would be defective then.
Yes, maybe better, maybe, but nothing has been informed by my client. Copy has also been served up to them. Yes, yes, I've checked it up. I could not find anything.
Okay. Mr. H. Chaudhary and counsel for the applicant, and Mr. G. Bharata is going counsel for the respondents.
All the respondents except 5 and 18.
I'm sorry, respondents, except respondent number 5 and 8 are present. Next, the learned counsel for the applicant has submitted that he has filed an application for substitution, setting aside abatement and application for controlling the delay on
9/3/26.
no, on death of whom?
On death of the respondent number 5 and 8.
On death of respondent number 5 and 8, which was filed on
For 9/3/26 file.
9/3/2026. So the same is not on record. Just to be learned counsel for the applicant shall find out if there is any defect
Yes,
in the
I-
application. Next, if there is no defect in these applications, the registrar shall place and tag the said applications. Stop. List again on, give a date after 10 days.
Item 20
My lord, appeal was admitted, my lord, long back, my lord, but consequential, this stay order was not, my lord, given in this IMR. In the appeal, lordship kindly will look, it was admitted, my lord, in the year 2013 on 9/1/2023. my lord. We are in possession of the land, my lord, the status quo as on today maybe not maintained.
The appellant is the plaintiff.
My lord.
or
No, my lord,
respondent.
no, my lord, we are a defendant original, my lord.
You are the respondent.
Yes.
This is A.M. Bordner and counsel for the applicant. None appears on call for the respondent. Why is this application for fees pending since 2019? The applicant shall produce a copy of a photograph of the suit land. The current photograph of the suit land containing the date and the geotag location. This from Monday. By Monday, you will get that photograph, geotag location, and the showing the land. Before that, you say none appears on call for the respondent. List on 1/6/2026.
My lord.
And in the appeal, no counsel for the appellant is present. Now that is on call for the respondents. Most of the case is ready as regards service and the TCR is received. It is noticed from the Wakatama of the substituted respondents available in the record that the new set of lawyers appearing for the substituted respondents are Mr. I. Ahmed, Mr. R. Sharma, Mr. D. Hazarika, A. Hussain, S. Sharma, A. Das, S. Nawaz. Mustafa Hawa. In the cause list only the name of Mr. I. Ahmed is mentioned. Accordingly, the registry shall reflect the name of the learned counsel for the substituted respondents as per the Wakatama filed on 11/5/2026. That's this is this is Wakatama. This is a number given. Just bring the number to listed on Monday. You need to wait here, huh? Monday. If you get the counsel for the other side, please inform them.
Malo.
Their names are not reflected in the cause list.
Obliged.
Item 21.
21.
I didn't really like the process of- So,
Well, IA number 967 was filed for substitution of legal heirs of respondent number 8, that is Sufia Khatun. It is said that some names of the legal heirs of Sufia Khatun have been wrongly mentioned, but that was allowed. If they want, they may appear.
No, the specific submission recorded here is that name of legal heirs of respondent date is wrongly reflected in the cost title. If it is wrong, it is no substitution at all.
Yes.
The this correct name is given today.
No, no, I got it, sir.
Senior listener. Then whoever probably got these names. Abul Kalam is here. And Abul Kalam is here. Then Shahjahan Ansari. Shahjahan Ali, yes, it is also there. Ansari is not here. Then Sabikun Nahar. Allowed. Steps of legally assertion. It appears from our substitution petition that some names are correctly written, some are not here. So here it appears only 5 names. But we have, we are finished, I don't know, this we have 1, 2, 3, 4, 5.
You are making a statement that the names are not correct.
These are not correct. We have provided them the
So
correct.
you file an affidavit, bring it on record. You see, these things create a problem. You are making a statement. You have an affidavit on record, then we'll consider that.
In 2023 itself, we had provided a correct list.
You've given 23.
Yes.
And that substitution petition we filed
This,
on in April 21. So thereafter, I think some, then, no, at present they have furnished 5 names, my lord. So we were allowed to substitute them. And if they want to bring the matter on record, we have no objection.
just give the list here.
Generally, iteration. After you pass it. Suddenly last time.
This every Mahmood and you read this in the main appeal. Mr. M. Mahmood and counsel for the appellant and Mr. M.K. Chaudhary and counsel appearing for the respondent numbers.
All accepted.
For all the respondents except respondent number 8 submits that on 28/11/2023 he had provided a list of legal representatives of Sufia Khatun, deceased respondent number 8. It was submitted that the fact that the names of legal representatives of respondent number 8 is wrongly reflected in the cost appeal was brought to the notice of this court, which is recorded in order dated 30/8/2024. Which is available in the record of IA Civil 2860 of 2019. The learned counsel for the appellant. Waits for some time to obtain instructions and to take necessary steps. List on, give a date after 2 weeks.
In the last order, some jury was asked to receive instruction. Can you see the last order?
Not Barua,
Borua, no? Sorry.
who is, you are for? We are together. He has already given it to you.
So whether he agrees with this, or again he will be in trouble because earlier those names were
But
given.
you see, he's taking responsibility and we have recorded his statement. He has given you a list. You have recorded the date when the list is given. You have that list. That's why we recorded. We asked him and he said that he gave it on that day. And you have that copy having a date and the signature of the counsel.
Actually, in my file, I do not see that. However, I will collect it from him.
15 June.
Item 22.
In this case, we filed an application for the registry.
But registry should not send a notice. You'll have to send a notice.
Lordship, that's why, formally I must refer leave from your lordship, otherwise. Lordship may notice. I'm told, my lord, that he may like to engage a different counsel in this case.
Das. It is empty procedure, no? Okay. It is procedure.
My lord,
Registry had taken the steps.
we have not taken this.
Registry the জানাইছি এটা একটা।
We have informed the registry, my lord. And we have informed the client also, my lord.
Okay. Mr. P. K. Roy, Leonard, Senior Counsel, assisted by Mr. S. Chakravarti, Learned Counsel for the appellant, has referred to the order dated 29/7/2024, wherein it has been recorded that the brief has been taken away from the learned instructing counsel. And the registry was directed to issue notice on the sole appellant. Next one is for the office note. Dated 11/5/2026. Pursuant to order dated 29/7/2024, notice was issued to the appellant. And the AD card is returned. So the postal tracking report is available on record. So it is noted that the registry had sent the copy of the order dated 29/7/2024 to the appellant. So according to the present set of counsel for the appellant is discharged from appearing in the matter. Next one, yes,
I'm appearing for respondent on 1A to 1E.
your name,
You Burva.
is U. Barwa, and counsel appears for the respondent numbers
1A to 1E, 3B to 3F, 5A to 5G, and 6.
Next one. as per order dated 5/15/2023, court had recorded that the respondent numbers 2 and 7 have expired. So no application for substitution has been filed. So accordingly, the appeal is awaited as regards the deceased respondent numbers 2 and 7. Next, there is a good foreign judge justice, the matter stands adjourned today. The court is made clear that if the appellant remains absent on the next date of the stay, adverse orders may follow. This time, give a date after 2 weeks.
June.
Item 23.
The law.
Yes.
We have taken the paper publication in this matter in respect of all the respondents except respondent number 6, because respondent number 6 has appeared in this matter. And one affidavit has been filed to that regard. So the affidavit starts from page 83.
Just now, You see, you are the plaintiff,
In the title.
right, in the
Yes.
title suit.
Yes.
Notwithstanding that you have served notices by way of newspaper publication, the order of the court is to serve notice in the widely circulated daily.
Daily revision.
I don't know whether how much of Assam Tribune is circulated in Barak Valley. In Barak Valley, there are local newspapers which have more credibility. Or sorry, circulation. Credibility is the wrong word.
Not true.
Correct.
Correct.
Now, please come to the respondent number one, address of respondent number one.
Not true.
So and so, wife of so and so, Main Road, Lachit Nagar, Guwahati. Please take me, after my court hours, after 4:30, we'll go together. We'll try to find out this Main Road, Lachit Nagar, Guwahati. I can give you 1 hour time, not more than that.
Not true. This was the only address that we could
So
found.
we understand,
Not true.
but you are the petitioner.
Not true.
Now, second is this, what you call for example, number 4, Sutava Chakravarti, resident of Oil Duliajan. This was a suit of 2006. Today, whether she is still in service of oil or not, we don't know. Because the court directed you to take usual steps, that was not taken. You took steps 1, it was returned. In the return,
Address we could not.
the addressee were not found, insufficient address, not known, addressee left.
Not true.
I'm asking you this because I read newspaper daily. But I never read a newspaper to find out my name in the agony column
is
of
true.
any court issuing a notice to me. It's not my normal habit. I don't know if people would read it. Law says that it has to be paper published. So law will prevail.
No.
But please tell me that if we don't have the proper address, how would somebody, some ABC will know that the notice is intended for him or her? Lachit Nagar Main Road. You don't expect anybody to come forward and say that, no, I will be the defendant. And this surname in Lachit Nagar, you will have more than one. Then you say, for example, there's some substitution, why I don't know. In the newspaper, serial number 18 is the Vigraha. Correct. As per your cost title, it is 19.
Not true. The respondent number 6 has entered appearance. That's why it is numbered as.
No, but
1 to
serial
18.
number would always be 19. You can't substitute the serial number to 18. 6 has appeared. Notice is to be served on respondent number 19. Can you refer it as 18? I don't know. And the address is, this is a Vigraha, that means it's a temple. It is, address is Radha Madhav Akhara. Is it sufficient address in future? No name, no address, no what you call the road name and all, nothing is there.
The lordship comes to page 69 of the appeal. They have filed that appeal. They have also
No, that's
mentioned
okay.
their
Somebody-
address as
you
main
see,
road.
you are the plaintiff.
Lordship.
You must know. You see, I am always conscious of the fact that order 6, you have the CPC with you.
No, lordship.
I'm just giving you the CPC. Order 6 rule 14 capital A and sub-rule 5. Where registered address of a party is discovered by the court to be incomplete, false or fictitious, the court may either of its own motion or an application of a party order. In the case where registered address was furnished by the plaintiff, stay the suit. I'm subconsciously aware of this. That's why I'm asking you. If you can just Google search and find out where this Akhada is. Just do this Google search, let us see if it is correct or not. This is a deity. A deity will not be reading newspapers.
No.
There will be some Shevat who will be doing it for him. And he must know that this Vigraha is for the temple in which he is the Shevat. Just do the distribution, come again at 2.
Lordship.
There's a meeting right now, so.
I think with the.
Order side.
No, that's the order I did.
Record. You have to bring the proper address on record. Did you notice the address? Any road or something is there? No.
No. It only says the Bilpar area of Ambikapur. Bilpar area of Ambikapur.
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 So that has to be included. So if the address is incorrect, the deficiency in address cannot be substituted by a newspaper publication of summons.
Responding to the performance.
How much time do you need to find out the address?
Further to
Hmm?
2 weeks, Lordship.
2 weeks, okay. But Mr.
KJ.
K. Jain, I'm talking for the appellant. He has referred to the additional affidavit filed, sorry, affidavit filed on 9/3/2026, being on record, the newspaper Assam Tribune, to which notice was served in a substituted manner upon respondent numbers 1 to 5 and 7 to 19. Stop. On a cursory examination of the addresses of the said respondents, comma, it appears that the addresses are vague. So accordingly, notwithstanding the order dated 16/12/2025, comma, by which the petition was, the appellant was allowed to take steps to without publication. But I've noticed the addresses given, which also includes official addresses and official addresses of government institutions. respect of respondent numbers 14 and 16. One court has to ascertain as to whether they are, those officers are, those persons are still serving in those institutions or not, because by accepting service, the acceptance of service should be on the proper address. Next, accordingly, the court is inclined to give the appellant a chance to ascertain the correct postal addresses of the respondents. Postal. Next one is paid for list. You see that the acceptance of the said affidavit file on 9/3/2026 is deferred to the next date of listing. Next list on after 2 weeks leave a date.
That's all.
Oh. Repeated class A, तो कोई नहीं, executive class A है, कोई नहीं. Mr. Chaudhary, you can send one of your matters to the court. In one of the matters we heard, your matter we heard on 22nd February, 22nd May. We had given the date of 28th, but the holidays have changed. So we'll be posting that to the next working date, either 29th.
Any day,
Yes.
Just a moment now. Yes.
We usually wants to confirm before listing, but 28th it can't be listed. 29th. Okay. Item 24.
My pleasure, Lordship.
Service, no service report in respect of respondent number 9.
9. This year. LC of TS number 134 has been received, but LCR of TA number 8 of 19 has not yet been received by the judge.
Please repeat again.
LCR of title suit has been received, but LCR of title appeal number 8 of 2019 has not yet been received.
In the title appeal, was there any what do you call it, additional evidence recorded? No.
No.
Then that may not be necessary. Just now. You are the defendants.
Defendant in title.
Yes. Defendants in appeal or suit?
Suit, Your Worship. I was the plaintiff. Respondent number one was the plaintiff.
Appellant number one is the plaintiff.
Respondent number one.
Nurullah Barbuya, yes.
Nurullah plaintiff.
He is the plaintiff
Plaintiff.
and you are the defendants.
The appellants were the defendants.
Appellants are defendants. You call for this scanned copy, but you don't think and in second appeal, the records of first appeal, if there is no evidence recorded, would be material. And against this respondent number 9, did you take postal steps also? Postal
Yes.
steps has returned back as addressee not known. Who is respondent number 9?
Bonjour, Rosper.
No, his status in the suit. She's a lady. What is her status in the suit? Manju Laskar.
Proforma is dependent.
Proforma.
Proforma dependent number 13.
She contested the suit? No.
No, it was. Suit was dismissed. In appeal it was dismissed.
No, but did she contest the suit? No.
No, no.
In the appeal also, she is not there.
Appeal has been made party.
So that's okay, but if
Only referent numbers 1 to 5 contested the suit. Filing joint written statement.
counsel for the appellants and respondent number 1 are represented. Are present. As per the service report available and office note dated 27/4/2026, notice is duly served on respondent numbers 2 to 8 and 10 to 22. So none appears on call for the said respondents. Next paragraph. The service report in respect of respondent number 9 is not received. And as per office note dated 15/10/2025, notice on respondent number 9 was returned with postal remark addressee not found, not known. Accordingly, the registry shall send a reminder to the Court of Learned Civil Judge within bracket Junior Division bracket close number 1, Silchar, to direct the civil Nazir to return the service report in respect of respondent number 9. Which was sent by for service by usual process by memo number capital HC full stop 26 Roman 26 XX VI oblique 2011 and 2012 oblique RSA dated 4/11/2025, bearing reference to the court order dated 29/10/2025. Next, the registry may send the reminder through email. So it would be permissible for the said learned court to return the process report through email for being placed before this court. Next para, list on due date after 3 weeks. Moreover, the registry shall also call for the scanned copy of the records of TA number
8 of 19. 8 of 19.
8 of 2019 from the court of Civil Judge number 1, Kachar, Silchar. Just a moment. It will record. It will record now. Not even record to look. And copy of file A of this title appeal number 8 of 2019. You're only asking for the records of part A of the appellate court. Other records are not required. Those will contain only Hazira and all other things, not required for us. Unless you say that there's an impropriety in the proceedings. If that is not there, then we are calling only for scanned copy of A file. This transference.
Obliged.
Item 26.
May it please your lordship. Your lordship, in this matter, respondent number 1 had died. So we have filed 2 IAs, one for substitution and one for amendment, my lord.
What is the date of death?
Your lordship, 26/2/2024.
2. Twenty-six to 24.
Yes, lordship.
Is any serious objection?
No.
Okay. Heard your name?
S.E. Murtaja on behalf of Ms. R. Chaudhary.
C. Murtaza and counsel appearing on behalf of Mrs. R. Chaudhary. Your counsel for the applicant. The applicant is the appellant in the connected RSA 51 of 2020. In 4128%, 4128. This is an application filed under Order 22, Rule 9 within bracket 2, read with Section 151 CPC for setting aside abatement of the appeal on death of the respondent number 1, namely Mohammed Maijud, M-A-I-J-U-D-D-I-M, Sheikh, S-K. So it is submitted that the respondent number 1 had died on 26/2/2024, and this application was filed on filed on 6/4/2024. No, sorry, 4/6/2024. 4/6/2024. Next part is notice that this application was found defective by the registry, as the affidavit in support of the application did not disclose that the deponent was authorized by the other applicants to file the application. So accordingly, the registry had returned the application to the learned counsel back on 26/2024, and the said defect was thereafter cured, and the registry accepted the application on 26/2024. Though the learned counsel for the respondent numbers 1 to 5 was objected to the application, but considering the explanation tendered, the same is accepted as good and sufficient cause which prevented the applicant from filing the application for substitution and setting aside the abatement on time. Full stop. Accordingly, the prayer made in this application stands allowed and the abatement of the RSA 2051 or 2020 is set aside. It shows a robust registry. They find out the defect and even in the affidavit, that's a good sign. Same application, same thing here in 4129. We say that last operative paragraph would be that do the learned counsel for the respondent numbers 1 to 5 have objected to the application, but considering the expansion tendered, the same as is accepted as a good ground, which prevented the applicant from substituting the respondent number 1. So accordingly, prayer made in this application is allowed and the substitution of the deceased respondent number 1 by the applicant numbers 1.1 to 1.5 is allowed. No, sorry, deceased respondent number 1 by the substituted respondent numbers 1.1 to 1.4 is allowed, 1.5 is allowed. Next, the applicants shall do the needful in terms of order which is being passed separately in the connected appeal. Okay, allowed in this process. And the appeal you say, in view of the order passed today, in IA Civil 2148 of 2149 of 2024, allowing substitution, the appellant, the learned counsel for the appellant shall file a amended cost title within 2 days before the AOJ second appeal section for being incorporated in the memo appeal and to update the CS data. Next para, the appellant is also directed to take steps within a week from the date of the order for service of notice on the substituted respondent numbers 1 to 1.5 by speed post with AD. Next, the learned counsel for the appellant is committed to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next, in addition to the postal steps, the appellant shall also take steps for service of notice on the said substituted respondents by usual process to be routed to the jurisdictional court. The notice by both modes is made returnable on due date after 5 weeks, made returnable on SWINSO, list on SWINSO.
Item 27 for orders.
One of the regular second appeal is against an order of reversal. The appellant was the plaintiff. That has been admitted, my lord, and there is also an order, my lord, to list it for hearing. My lord, the IA number 3322 24 is before lordship for consideration. In here, my lord, in this case, an injunction has been applied for in this IA, and my lord, because of the difficulty in service of notice, my lord, the notice was issued that could not be served That's how much of the matter is listed before your worship now. Now, my lord, the facts are very brief, my lord. The suit was for declaration of right title and interest over a small plot of land about 5 acres over which a shop exists. Your worship will know, my lord, that is situated in Panchi Bazar. The shop is, my lord, Minu's. Now, my lord, in this IA, the prayer made is that, my lord, during the pendency of the appeal, the status quo in respect of the suit property to be maintained, so that, my lord, that is not alienated. And also, my lord, there is a prayer that, my lord, the rent should not be collected from the tenant. Instead, my lord, that should be deposited in court. That is the prayer made, and they have filed their objection. We have also filed a reply to their objection. So that is my limited prayer, and my lord, I want an early hearing of the, my lord, bill also. That will be the prayer, my lord, without there being an application.
If I have the permission to speak, my lord.
No, I think I may not be able to take up this matter.
My lord,
I think I may not be able to take up this matter.
oh, I am sorry, my lord, I am not aware. Yes, sir, Kumar.
One of the parties is a lawyer. Right?
My lord.
Where? Oh, yes, my lord.
Then.
My
that's
client,
no.
my client is a lawyer.
Hmm?
My client is a lawyer. My appellant is a lawyer.
One of the applicants is a lawyer.
My.
I'm
Then I may not
respondent
be
number
able to
3,
take
I'm also a lawyer.
Huh?
I'm respondent number 3. My senior is appearing on behalf of me. I'm also a lawyer.
No, not that.
No.
Not because of you.
No.
Because of, there's a lady lawyer. Okay, no, then no. This is the matter before any other bench without one of us, without me, K.S. Banerjee. So for others, there's no difficulty to take up, but
My lord, in that event, my lord, may I please let it come after 2 weeks, my lord. I have got some difficulty using this paper before any other court. After 2 weeks, my lord. What is date may be given?
okay, so is there any date when you want?
Immediately after 11th, my lord.
After 11th,
My lord.
that gives us 12th.
Right.
And paid for by the scientific organization in the council for the applicant, public appellant, this on 12/6/2026.
Definitely, right, my lord.
Twenty-eight.
Their pleasure, as per official dated 26/2. Some of the respondents have entered appearance.
One D expired.
1 day expired.
Respondent 2, no such person in the address.
Yes. 3, 5, and 6, no ID card. 4 is without postal endorsement.
You take the usual process also.
Yes, Lord.
So G Bharadwaj and counsel for the appellant and
And for the respondent.
your name,
One A, B, C, and E.
your name.
M. Devi on behalf
Ms.
of.
M.
respondent.
Devi, the counsel for the respondent numbers 1A, 1B, 1C, and 1E. As per if you are appearing for respondent numbers 1A, 1B, 1C, then you have to tell us who are the legal representatives of Ruma Mandal, the person who has died. Is your sibling.
Yes, sibling.
Or as the state of respondent number 1 is duly represented, you can also strike out her name. Yes.
I have no other instruction with you.
No, that for that you'll never have instructions. We are just putting a query. You see, the respondent number 1 was the defendant number 1. He died. His state is represented by A to E. Now, out of this, D has died. So the state continues to be represented by others. Either we are asking you now, either you ask you give you time, you disclose them, or we strike out the name of respondent number 1D. Correct. You take instructions within 2 weeks and get back with instructions. That is one. Now, respondent numbers 2 and 4.
So respond number 2, my lord, I will file an IA. He did not contest the suit.
No, that's your choice, because if it is there, you'll have to take steps. Otherwise, we have to strike it out. So for this number 2 and 4, you'll have to get the correct address. And if you want, we can strike it out. That's your choice.
Respond number 2 can be struck out.
Strike down. Okay. The as per the learned counsel for the appellant has submitted that the pro forma defendant number 2 in respect of whom the postal article has returned back, postal steps has returned back with endorsement, no such person in the address. Now, it is submitted that the said performer respondent 2 did not contest the suit. Or in the appeal, Mr. Prays that the name of respondent 2 be struck off. So the prayer is allowed, the name of respondent 2 is struck off at the risk of the appellant. Next para. In respect of respondent number 4, the service report is returned without any postal endorsement. What is the name of respondent number 4?
Biswajit Mandal. Biswajit Mandal.
Vishwajit Mandal. So there is no postal remark, but it appears that the postal authorities had twice redirected the postal article to different post office under pin code 782140 and 782125. So therefore, it is presumed that the notice could not be served due to want of proper address. As per the office note dated 26/2/2026, neither ED card nor answered notice has been received in respect of respondent numbers 3, 5, and 6. As per accordingly, the appellant shall find out and inform the court about the correct postal addresses of respondent numbers 3, 4, 5, and 6. Postal. List again on, give a date after 2 weeks. Just one more before that. You see since the state of the principal defendant number 1, on death of principal defendant number 1, he was substituted by 5 legal representatives, out of which substituted respondent number 1D has expired. So thus, though the estate of the original defendant is duly represented, still the learned counsel appearing for respondent numbers 1, A, B, C, and E is asked to obtain information as to whether the respondent numbers 1A, 1B, 1C, and 1E are ready and willing to disclose the name of the legal representatives of the deceased respondent number 1D, failing which as the state is duly represented, the court may take a call as to whether the name of respondent 1D can be struck off. Next para, the learned counsel for the respondent numbers 1A, B, C, and E shall obtain instructions and inform the court list That's for this on, so same date, 2 days, after 2 weeks. Aliability.
Item 29.
Lordship, as per office note dated 18 March 2026, Lordship.
Yes,
Service completed, Lordship, and the LCR has also been received, Lordship. The matter is ready for hearing.
no,
Lordship,
on
kindly-
respond number 2, it is no such person returns to sender. Respond number 2 is not served.
Lordship, respondent number 2 has entered appearance by filing occurrence number, Lordship. In first list also, his name has been shown.
Is it?
Mr. N.C. Das.
Okay.
Appeal is already been admitted, Lordship.
Records have come. Okay.
My lord, I'm appearing for the respondent number 1. Lordship, kindly see the order dated 30th of July 2025, passed in IA number 2386/2025. This petition IA is followed to stay the operation of the execution case. And it was passed on 30th July 2025. It is hereby directed that till returnable date, the further proceeding of the execution case number 6/2025 pending in the Court of Learned Civil Judge, Junior Baksa shall remain state. There has been, my lord, before passing this order, my lord, the execution case has been disposed of, and that was, my lord, on 29th July 2025. And possession has been given, all these things have completed, my lord. So it becomes infructuous, this IA now. These are the order, my lord.
1 day prior to stay by this honorable court, Lordship, the execution was completed.
No, still,
Yes,
Yes,
this
Lordship,
is
there is,
right, if it is taken, then this order would become infructuous.
infructuous. I become infructuous. And so far, the execution case is completed and possession has been given, my lord. My prayer is to, my lord, till, my lord, hearing, my lord, status quo may be maintained, my lord, lordship may direct it, my lord.
It is IA.
Lordship, may I submit, Lordship? Lordship, though the execution is over, Lordship, the execution or recovery of the Suitland was a part of the order, Lordship, part of the decree, Lordship. There is another decree also about permanent injunction and with respect to cost, Lordship. And in the title suit, they prayed for record of revenue record also, Lordship. That's why my humble submission, though the recovery of possession part is complete, but that decree is not totally executed, Lordship. That's why the IA is not infructuous, Lordship. And that may be disposed of, Lordship.
Being infructuous, disposed of.
As because there is the cost has been imposed upon the appellant plaintiff, Lordship. Cost has not been recovered till that, Lordship. And with respect to the
prayer made by the learned counsel for the respondent number one with respect to status quo, I have no objection.
No. Let me recapitulate what you are trying to say. You are saying that there's a decree for the correction of revenue records.
In their prayer, Lordship, in the prayer of the title suit, there is a correction of revenue record. But in the decree, Lordship, the correction, with respect to correction of revenue
There's no order.
is not mentioned in the Lordship.
So therefore.
But there is mention, the learned first appellate court has mentioned about cost, Lordship.
You are the appellant.
I am appellant, Lordship. Lordship, at page 66, Lordship.
Just wait.
Are permanently injuncted from entering into
Just a moment.
67.
You see, at times it is always good to be silent rather than make a statement.
Yes, Lordship.
Come to page 45. In
Yes,
page
Lord.
45, this is the decree.
Yes, Lordship.
The cost column is not even filled up.
Yes, Lord.
But now you have brought this to the notice of the appellate court. Now we'll always say that the decree be modified to include cost. He has not even made a objection with regard to non-inclusion of cost. He has brought it to the notice, and then as appellate court, we can't remain
Lordship.
silent.
Yes, Lordship. Not mentioned. Actually, Lordship, same thing happened in the.
Whatever, but if there is no degree of cost, this decree would have, now Mr. Surya knows it. Now we'll have it, have the decree corrected, have it included.
Lordship, at page 70, Lordship, it has been stated the cost of the original suit are to be paid by the defendants to the plaintiff.
Correct, but that's
of
not a
the
part of the
original.
decree.
In title appeal decree, Lordship.
I don't know if Mr. Surya has understood me, he will thank you.
67.
He will thank you. But it's not a part of the decree, so it
My
can't be
humble
exercised.
submission, Lordship, the stay application may be disposed of.
Has to be disposed of because there is nothing more to be executed.
Other is the appeal is ready for hearing, Lordship.
I'll take it up.
As the Lordship, my humble submission, as the respondent number has already taken position of the suit, Lordship, the matter may be fixed for hearing, and that may be fixed, Lordship.
We'll fix it, but not now.
Yes, Lordship. Our book is required.
We'll fix it for orders and thereafter we'll commit for hearing because these days we cannot, we are taking up old matters
Any
only.
date after vacation, Lordship.
Okay. In the appeal, you say, all sides are represented as the case is ready, regard service, and all the respondents have entered appearance. The case is ready for hearing. So, list on so and so, give a date after the vacation, this one so and so, for passing necessary orders for listing the matter for hearing. Now, in this, in the IA, you say all sides are represented. Next, the Mr. T.C. Sutyal and senior counsel
assisted by Mr. D.K. Roy, learned counsel for the respondent number one, has produced a certified copy of order dated 7/8/2025, passed by the learned civil judge within bracket junior division bracket close Baksa in TX number 6 of 2025, disclosing that as per the report of the civil Nazir and Lot Mandal's report, the decree has been executed and the possession of the decretal land was handed over to the decretal holder, who has confirmed that the decree has been fully executed and no further coercive or substantive steps remains to be taken in execution. Thus, it appears that the execution proceedings as per the order dated 7/8/2025, referred above, was executed on 27/9/2025, which is a day prior to this court passing an interim order on 30/7/2025 in this interrogatory application. Next paragraph. Therefore, with the executed with the in view of the order dated 7/8/2025, this interrogatory application has become infructuous and accordingly closed. So you should not have said that. You have invited trouble for that 13,000 rupees now. The order itself says, accordingly, a decree has already been executed in full and nothing survives to be adjudicated in the execution case.
Actually, I have
So
not
now-
gone through that order.
That's okay, but that's why you said at times
Yes, okay.
remaining silent is more
Yes.
better than
I do.
saying something.
I agree.
Mr. Dhar, you are appearing for?
Respondent number 3.
Mr. A. Dhar, then counsel appears through video conferencing for respondent number 3. Okay. We record your presence in both the cases.
Obliged.
That one, 5 July.
3rd July. After that, we'll fix a date for hearing.
Highly okay, sir. Obliged, sir.
Just record the names of Mr. U. Sharma for the appellant applicant, Mr. T.C. Smithya, along with D.K. Roy for D.K. Roy for respondent number 2 and Mr. A. Dhar for respondent number 3. Record the presence. Okay. Item 30.
May please respond. Here, I appeal for respondent number 1, 3, and 4, and while framing the substantive question of law, on 8/8/2025, I pointed out last paragraph, of the order, 8/8/2025, that the pro forma different respondent number, 2 and 3, expired, already. Therefore, there is a direction for taking steps to bring their legal heirs in the area of party, and that perhaps that steps has not been taken by the applicant.
Okay.
Madam.
Mr. D.K. Das, counsel, appears for the respondent. For all the respondents,
No, respondent number 1, 4, and 5,
respondent number 1, 4, and 5. He submits that his statement, his submission that the respondent numbers 2 and 4 have already
2 and 3.
died, 2 and 3 have already died in the year 2009 and 2020 respectively, is recorded in the order dated 8/8/2025, which was passed in the presence of the learned counsel for the appellant. So he submits that appropriate steps has not been taken till date, and accordingly the appeal has abated. Next para. We take notice of the fact that though the appellant, the name of the learned counsel for the appellant is on record, but the names of the learned counsel for appellant is not reflected in the cause list. So accordingly, the registry shall list the matter again on 1/6/2026, disclosing the names of the learned counsel for the appellant, which appears in the record of this appeal. Next para, this order shall be brought to the notice of the AOJ, second appeal section, civil division section to doing it. Okay.
Item 31.
Because in this matter, the notice, my lord, could not be served on the pro forma respondent, number one. We have taken steps earlier. Now, my lord, my prayer would be to delete the name of the, my lord, the pro forma respondent number one. Because, my lord, she did not, she filed a writ petition saying that, my lord, she doesn't have any objection to the prayer in the plaint. She does not have any objection to the prayers in the plaint. I was the plaintiff, my lord. She filed the written statement supporting my case and, my lord, saying that she doesn't have any objection. Therefore, my prayer would be, my lord, to delete the name of respondent number one at my own risk.
Respondent number 3.
Pro forma respondent number one.
Pro forma respondent number 1.
Even a pro forma defendant, but filed a written statement saying that she doesn't have any interest in this property.
No. Pro forma respondent number 1 is not there. Here is remembered as 3 and 4. 3 and 4, not pro forma.
No, my lord. My lord, while filing the CRP, my lord, we indicated her as pro forma respondent number 1, but my lord, it has been now in the list.
Well, accepting, because you see there in the CS system, there cannot be 2 respondent number 1.
Yes, my lord, serial numbers have to be maintained. So it will be, my lord, pro
3.
forma respondent number 3.
Okay. For others, the service is complete.
For other service company.
You are appealing for
Appearing for respondent 1 and 2
1 and 2.
on behalf of S. Biswas.
Okay. Heard Mr. M.K. Chaudhary and Senior Counsel assisted by Mr. M. Sharma and Counsel for the appellant, as well as Miss
T.H. Mira.
Learned Counsel appearing on behalf of the Learned Counsel for the respondent numbers 1 and 2 on record. Next para. As per office note dated 11/3/2026, notice is served on the respondent number 4. So none appears on call for the said respondent. Next para, in respect of respondent number 3, the learned senior counsel for the appellant has submitted that in the written statement, the said respondent had filed a written statement and
That your worship will find, my lord, as
no, it's okay. Once you say it, not explaining, and has stated that she has no objection to the decree being drawn in favor of the appellant. So accordingly, it is submitted that the as per instructions received, comma, he prays that the name of respondent 3 be struck off. Full stop, the prayer is allowed, the name of respondent 3 is struck off, comma, however, comma, at the risk of the appellant. Petitioner.
Petitioner.
Next, but as the case is ready as regards service, comma, list the matter in the admission column. This is against the prayer for amendment.
My lord, the matter is regarding amendment of the written statement that was allowed by the, my lord, the court below. And our stand is that, my lord, after the issues have been framed, the amendment cannot be a small issue. The counterclaim cannot be allowed to be filed. That is the, my lord, point to be decided.
Counterclaim.
Counterclaim.
There's something wrong. I read somewhere about written statement being amended.
Yes, my lord, that is how the prayer was made.
Okay. But in fact, they have introduced a counterclaim.
Yes, sir.
Where is that amended written statement with counterclaim?
My lord, the petition is at page 53.
No, the amended written statement can come counterclaim.
No, my lord, they have only filed the petition, my lord.
They have only filed.
Only filed the petition.
But if there's no order passed, then the revision would not be maintainable.
My lord, by the interim order, my lord, that amendment was allowed.
So that's why after amendment allowed, they will have to file an amended written statement.
That has not been filed yet, my lord. The prayer your worship will find in that petition at page 57, my lord.
You've seen order 6 to 15.
My lord?
You've seen order 6 to 15.
Yes, my lord.
What does it say? Give me CPC.
Thank you. Verification of pleadings. Order 6, Rule 15 is, my lord, verification of pleadings.
No, order 6, no, order 6 to 18.
Amendment of pleadings. That is, my lord, 17.
17 was allowed.
My lord.
18.
Failure to amend after order, myself. That, of course, my lord, after we file this petition, whether in the trial.
No, now you are extending time. By filing this, you are extending time for them. Now everything would be subject to the orders of the court.
Yes. But then, my lord, at the first place, the prayer could not have been allowed.
I leave it to you. I have got nothing to say.
I understand, my lord.
Okay. This is the matter in the admission column. Give a date after 2 weeks.
The lordship fixed any date, right?
I have told earlier also.
That is interesting.
I have told earlier also, when I taking up writ matters, too much of CPC makes Jack a dull boy.
So that makes it interesting also, my lord, that aspect.
No, I don't know.
But in the event, my lord, the order that has been challenged in this, my lord, the revision petition, that is allowed, my lord, the consequence of order will also, my lord, go if the amendment petition has in the meantime been filed.
Just a moment, just a moment.
For position 9. For position 9. And my lord, record has not been called for that, therefore.
It's not required.
No.
The record is not at all required.
No, that may give advantage to them, that is what I am pointing out.
No, no. Okay.
Your lordship will examine it on the next date, my lord.
Yes, yes, I've already examined it.
So like,
32.
In this appeal, office note indicates that respondent number 3 and 4 died. And 1 and 2 has appeared through their path. I'm appealing for 1. And Mr. A. Paul, learned counsel for the appellant, and Mr.
W Hawk, W Hawk.
W. Hawk, learned counsel for the respondent numbers 1 and 2. Next, in view of office note dated 6/4/2026, indicating that respondent numbers 3 and 4 have expired. The learned counsel for the petitioner plays for some time to take instructions and do the needful. So matter stands adjourned today, list after 2 weeks.
33.
We'll go for hearing. Matter is ready for hearing now. This is 2025. It will take some time to be listed. The appellant and the respondents are duly represented. So the trial court records, the TCRs are received. So accordingly, the case is, the appeal is ready for hearing. So, as this is a this is the matter, give it date after the case. This is the matter of so and so for fixing a date for hearing. Much of that. July 2030. 34.
It's number 1, it's clear.
But you're taking a big risk of not taking steps
taking
on the
steps.
other respondents.
Yes, my lord.
You have to strike them out.
I will take step, my lord.
We'll have to strike them out. The order was passed on 3/12/2025, but you've not been taking steps for 4 months.
Yes, my lord. By Monday, I will take my lord.
Mr. A. K. Azad, when a counsel for the appellant undertakes to take steps by 1/6/2026 for service of notice on the respondent numbers 2A, 2B, 3, 4A to 4J and 5. To stop. Next paragraph. Mr. N. K. Kalital and counsel appears for respondent number 1. Next paragraph, the appellant shall take steps by 1/6/2026 for service of notice on the respondents referred above by usual process as well as by speed post with AD. Stop the notice is made returnable on give a date after 5 weeks, returnable on so and so. The learned counsel for the appellant is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next para. Insofar as usual process is concerned, comma, the concerned court through which process would be served is requested to see that the service report is returned to the court prior to the next date of listing. Next para, list on so and so.
20 July.
Already.
35.
Lordship, I am appearing for sole respondent.
So none appears on call for the appellant. So however, comma, Miss
P. Odikal.
P. Adhikari, learned counsel appears for the sole respondent. And so the records, the PCRs are received. Accordingly, the case is ready for hearing. Stop list on so and so. For fixing a date of hearing. So again, for fixing a date of hearing. No, no. Motion is দিব কিন্তু আমি একে ডেট দিব বাট সব ফিক্সিং অন ডেট অফ হিয়ারিং এটা ডেট অফ দিব সব
22nd July.
Yes, item 36.
My lord, after the date of the loan respondent, as per office note, that we have office note dated 23/4/2026. Service is complete upon the name of the respondents who were furnished by the respondent. Lordship, this is a old pending matter, Lordship. Allowing our petition, it may be fixed for final hearing. Since 2013, there is case for that. One for donation petition, one petition for substitution, and another for everything. They are not opposite. In the month of July, 2013 matter, my lord, then judgment and degree has been stayed. At best, there should be a final hearing, like the petition.
Mr.
R. Islam.
R. Islam and counsel for the applicant. As per by this application under Section 5 of the Limitation Act, the applicants who are the appellants in the connected appeal paying for only the delay of 198 days beyond the period of limitation in having a substitution petition on account of death of sole respondent, namely Viraj DI RAG Viraj Molla MALLA Barua BARUH. Notice on the substituted notice on the legal representatives of the deceased respondent was served by usual process, and as per the process service report available on record, notices on respondent numbers 1A to 1D were all received by the respondent number 1A. Accordingly, notice this is duly served. Someone appears on for the said respondents. Next paragraph. It's projected that the death of the respondent came to the notice of the appellant only on 26/11/2024. After the same was informed to the court, and accordingly, it took some time to present this application, and accordingly the delay it was next for now. Considering the fact that the respondents, the persons sought to be substituted are not present, the notice is duly served, comma, the explanation tender is accepted as good and sufficient cause which prevented the applicant to file the application for substitution within time. Substitution and for setting aside abatement in time, so accordingly the chair is allowed the delay of 198 days beyond the period of limitation in presenting the said two applications is hereby condoned. So this I and disposal. This will be in 430. Then in 431 is, sorry, 432. 432 is an application for setting aside abatement under order 22 rule 9 within bracket 2. Rest of the order will be same. Then the last page you say that according to this application, understands of which also stands allowed. The abatement of the of RSA 4242 of 2013 on death of the sole respondent is hereby set aside. Application stands allowed and disposed of. Yes. Then next order will be in 431. Rest of it will be same. And last we say that application for substitution filed under order 22 rule 4 of the CPC. Court stands allowed. And the name of the deceased respondent, sole respondent in RSA 242 is of 2013 is permitted to be substituted, is allowed to be substituted by the opposite, by his legal representatives who are arrayed as respondent numbers 1A to 1D in this application. That's fine. The application stands allowed and disposed of. Then appeal, you will say, and so in view of order passed today in the connected IA Civil 432 of 2025 and IA Civil 431 of 2025, comma, the appellant, the learned counsel for the appellant shall submit amended cost title to to the AOJ Civil Division section for being incorporated in the memo appeal and for updating the CIS record. The same shall be done within 3 working days. Next para. The appellant shall take steps for service of notice on the substituted respondents by speed post with AD. So as to put the substituted respondents to notice that this appeal was admitted for hearing by order dated 23/4/2014. The following two substantial questions of law.
Lordship, their counsel has appeared as shown in the call list. I may be given the liberty to furnish them copy.
No, they should have said earlier, then without them, we will not pass an order. We would not have allowed this substitution. You permitted us to proceed by. Who is the lawyer for the substituted respondents?
As Bhattakur, Mr. S. Bhattakur. All right, I will. All right, as your lordship pleases.
फिर उसको तो गलत पर दिखाना है इस बॉटल को नाम तो कहने का दिख लो गलत पर थकी बोलेगा ना या तकले तो ना गलत पर थकी बोलेगा ना कॉफी ब्लैक बात दियो कॉफी कॉफी में सही दियो वो कॉफी ब्लैक ना लगे ब्लैक को साइड ऑफ तीन भाई वो तो देखना है वो करना सो बाकी का सामना लगे वो करना से नहीं गलत ना से नहीं बाकी सामना लगे So just check in this just check in connection with this IA 430. Is there a authority on record for the respondent? IA 430 or 2025? Paragraph is correct. Particular document is not mentioned. If filing document number, so and so. What is this? This is not affidavit here. Okay. Affidavit. 2017. That is in 2017. No, it can't appear here. Just add a line in the main 430. You say that although in the cause list, the name of the counsel for the respondent appears as Mr. S. Bhattakur, but it is noticed that the Wakalatnama of Mr. S. Bhattakur was filed on 21/9/2017 in RSA 242 of 2013 as the counsel for the respondent. Mr. We said respondent had expired, and in this application for condoning the delay, no fresh Wakalatnama of the opposite parties who are the legal representatives of the sole respondent has been filed. So stop, just comma. From the materials available on record, comma, there is no counsel appointed by the substituted respondents. The person sought to be substituted as substituted respondents. That's all. Huh? After that, just record this. Then this various directives steps to be taken. First steps, the steps to be taken by speed procedure as by usual process. The notice is made returnable on yesterday. You have to give the amended cost title, then take steps within a week from the date of the order for service number 22nd July. For appearance by the council, I am very, I take special notice so that there's no injustice suffered by the party just because the office makes a mistake. As Bhattakur's name appeared here by default, he is not the advocate appointed. I take special care for this and service of notice. But I've seen people suffering because of that. If I have missed it, it would have been a blunder on my part. That's why I again checked all the records. Each and every, there's no Wakalatnama of respondent of Mr. Bhattakur on record for the substituted parties. Yes, item 37.
In this case, the appellant filed an application under order
2A.
for violation of the order of status quo granted by the court. It happened like that. We filed the application in September, but my instruction today is that after filing, Because I filed this because the respondent was trying to transfer this with property, that is why, despite there was an order.
But how it will be a contempt?
There is an order. In fact, what happened, the suit, the appellant was the plaintiff. He filed the suit saying for cancellation, declaration, cancellation, injunction, in respect of a revocation of gift deed made after about 23 years. Now, when I filed the suit, the plaintiff defendant also at that point of time tried to transfer the suit forward. There was a injunction order passed by the Transport also on that basis. So again, after the main appellant died and was substituted, they now sought to get it transferred. Therefore, they filed. Now, my instruction yesterday is that they are not proceeding after filing of this. So,
Even if they do, I would not have entertained. The reason is that there is an order of status quo. And transfer pending right is otherwise permitted. They will only be covered by the decree. So you don't suffer anything.
But why I filed the law? Because the landed trial court take a note of it and restrain them to alienate. On that basis only. So
No,
they are
no,
actually repeating this.
But what I've understood.
True, my lord, the lordship is right. Otherwise, my lord, I am not disputing that. My prayer is, my lord, at this stage, therefore,
to close this.
they have not also filed objection to this. So my prayer before lordship is that since they are not, my instruction is they are not proceeding, lordship will treat the matter for final hearing. That will be if my
But to know about the contempt, it has to be closed.
I will
If you have
close it,
sufficient
but
cause of action.
my prayer, my other prayer may be granted.
Okay. This RSA of 21, we will fix a date after the vacation to fix a date for hearing.
Lordship.
Because it's not possible right now to fix a date for hearing.
That's all right.
These few days I am taking up only the old matters for hearing,
Right.
time permitting.
That will be after the summer break.
This will be in IA 3288. Heard Mr. P.K. Rod and senior counsel assisted by Mr. S. Chakravarti, learned counsel for the applicant, S.K. Chakravarti, learned counsel for the applicant. Also heard Mr. D. Mazumdar and senior counsel assisted by Mr. D. Mazumdar, learned counsel for the respondent. Next, the learned counsel, senior counsel for the applicant has submitted that pursuant to filing of this interlocutory application, the alleged process that was taken up by the respondent to transfer the suit property has not been pursued. So accordingly, does not press this application with liberty to approach again if cause of action arises. So stop. Mr. Mazumdar, I have to hear you for something and then say that I have heard you.
If the lordship wants to hear me, I'll say some other story.
Yes, yes.
My
You
sister,
see,
my
So
sister
far as I am concerned, for the bench, you have the immunity to tell stories. But the
I'll not
same,
take much time.
No,
There are the lawyers
but-
sitting behind.
for what happens thereafter, the court will not be
That
responsible.
is why I kept quiet. But otherwise, I was hearing that they have got some matters. So it's better I don't open my mouth to cut short the matter. Lordship has already.
Okay. Having heard the senior counsel for the respondent, some of the prayer is allowed, the matter stands closed. Will not be pressed with liberty as grateful. And in appeal, you say, as the case is ready as regards service and the records are received, list the matter on so and so for fixing a date of hearing. 22nd July.
All right.
No, it was only technical because if I have to hear you, then you can't go and say that, no, I was not heard and the court recorded. heard.
In one sentence, I can say what has actually happened. Property belongs to me. There is a sale deed in my favor. They have challenged the sale deed. That is the merit of the case. But my sister is unmarried. She is staying there. She was gossiping with somebody whether I can sell it. That she cannot sell because she's not the owner.
My lord,
No. I'll tell you, not now, but post debiting my office.
Yes.
If you want me to sell the Taj Mahal, I'll do it.
That is what has
You
happened
must-
here.
You must find out a gullible person with a lot of cash, and then you will just come to know what I can do.
If they are not burnt.
Huh?
If the cash is not burnt already.
No, I don't know. I'm not saying that. I'm just saying it on lighter note.
Well, I also.
Post debiting office. You can
my lord, instead of 25, can be 29th, my lord.
29th, okay.
Obliged.
But it's only a lighter note, not to be at all.
Yes. But I also said in that way only. Very lightly.
38. They died before filing the appeal.
Yes.
The respondent two died
Yes, Lordship.
before filing of the appeal.
Yes, Lordship. It was Lordship, today 1425 has been listed. This is an injunction petition by the respondent.
No, first we'll have to deal with the interlocutory application for implement.
Lordship, that 880.
Number I will not remember, just wait for some time.
Lordship. The last one, Lordship,
The,
ISCV 880.
just a moment.
50.
We'll allow this application first for implement because he died after the decree.
Yes, Lordship.
Third, Mr. A.C. Sharma, Runner Senior Counsel.
Lordship, in 880, I am for the applicant.
880,
Yes, Lordship.
you are the applicant.
Yes, Lordship.
Okay. We'll allow the application. This is R. Chaudhary, Runner Senior Counsel, assisted by Ms. S.E. Counsel for the applicant. Also had Mr. A.C. Sharma, Runner Senior Counsel, assisted by Mr. G. Bhargav, Runner Counsel for the respondents. Respondent numbers 1 and 3.
Only one, Lordship.
Only one. What about 3?
3 we are not different.
Okay, only for respondent number 1. This application has been filed. This interlocutory application has been filed under Order 1, Rule 10 of the 10 read with Section 151 CPC for implement of the legal representatives of the respondent number 2 who died on 30/10/2025. Next para, it is noticed that the appellate judgment and decree was passed on 22/9/2025, and therefore the respondent number 2 had died after passing of the first appellate judgment and decree and before the connected RSA 1 of 2026 was filed. So under the circumstances, this having heard the Learned Senior Counsel for both sides, the here made in this interlocutory application to implead the legal representatives of respondent number 2 as respondent numbers 2-1 to 2-5 is 2-1 to 2-5 as provided in the cost title of this application stands allowed. So this application stands disposed of. And in the appeal, you say in view of the order passed in ISBL 880 of 2026, the appellant shall file an amended cost title by handing it over to the AOJ Civil Division section for incorporating it in the memo of appeal and for updating the CS data.
Okay, good. We have
Full stop. Next, as per the office note dated 25 to 2026, the process through process servers was duly served on the respondent number 3, which was accepted by his wife, who is an elder member of the family and therefore has none appears on call for respondent number. Therefore, service is complete on respondent number 3. Post of none appears on call for respondent number 3. Yes,
LCI from both the courts received.
880 goes. Now it is 1425.
Yes, sir.
And what is this IA 58?
58, Lordship, in connection with the regular second appeal, Order 41, Rule 5.
Application. And 176 is disposed of.
Yes.
Now 145.
1425.
Oh, yes, 1425, right. I'm
But
sorry.
this application has been filed by the plaintiff respondent. But the plaintiff got the degree in the trial court as well as in the appellate court. In appeal, their appeal was dismissed against that. The appeal has been filed and admittedly appeared. Now, very recently, the respondent, the appellant opposite party, they are now trying to raise a construction over the children. There was Hatchet House, now they demolished some part of the original structure and raised some RCC posts and other things. I have annexed the photographs. That photographs will clearly indicate that they are doing job of raising permanent structure, RCC structure over the shootland. Therefore, my prayer before your Lordship is this, that during the pendency of the appeal, the appellant may be restrained from raising any construction over the shootland and status quo will be maintained.
In this case, Lordship, I have information that one house, Pradhan Mantri Gram Yojana, Lordship, he received. So unless until any construction is made, Lordship, the second step, second installment was not provided to the applicant, Lordship.
But you cannot carry out construction.
Lordship, I am undertake to hand over it. If I lose the case, Lordship, I undertake to.
No, he may not want it.
Lordship, along with the entire Lordship
You
house.
see, permanent construction, he may not want it.
Yes.
Want to know the reason?
Lordship.
You want to know the reason?
There is no demolition there.
Yes, the cost of demolition will be higher, and then in the demolition, when it takes place, third parties will come and say that I am inducted in the house. I have a third party right.
No, Lordship, in fact, it is a residence, Lordship.
No, that we don't know.
So that we can
But
make
in every
clear,
execution, we find at least 2 applications coming in. One claiming objection for as a third party, and then somebody comes in and says that no, I've been inducted in my own right. claiming title over the house, so it's very dangerous.
His lordship may record my undertaking that.
No,
But
no,
that
no.
undertaking will not do,
Or lordship,
because
I'll
they
file
will
an
raise the
affidavit,
construction, they will leave their.
I'll file an affidavit that if I lose the case, then I will hand
You
over
do it, then we'll give a temporary injunction and then we can make it with that undertaking.
the lordship.
Till then you don't proceed. But I'm just asking myself, if we don't know what happens in the litigation, who wins we don't know. But if the title is disputed, would the availing of the Prime Minister Housing Yojana would not be illegal?
Lordship,
I'm just putting a hypothetical question. A gets the Pradhan Mantri, that house Yojana. He constructs it and then B gets the delivery of the property. B was otherwise not entitled to have that Pradhan Mantri that house Yojana. So what happens if this is a collusive suit for transferring the land from A to B with a house?
lordship, we are not
No, ma'am.
transferring the land. It is there.
See, you may be a good person, but sitting here we become bad. We think many things.
I'll ask them to give that
There's
undertaking.
a
that
small
if-
poem. There's a small poem. I think a thing, a funny thing, a funny thing I think. And if I think the same thing you think, you think the same you think. So the thinking process is so fast that sitting here we have certain negative thoughts coming first.
As per the case of the defendant.
No, you
he
file
has
your
not-
objection, we'll issue notice, but in the
Lordship.
meantime, don't proceed with the construction. Till we pass further orders. Heard, this is IA
1425.
1425 2026. Next paragraph. Heard, Mr. A.C. Sharma and his senior counsel assisted by Mr. G. Bharadwaj and counsel to the applicant. Also heard, Ms. R. Chaudhary and senior counsel assisted by Ms. S.E.
S.E. Murtaja. S.E. Murtaja.
Asha.
Narrative.
Counsel to the respondent. Next paragraph. The applicant herein is the respondent in the connected RSA 1 of 2026. So he was the plaintiff in the suit.
Yes, lordship.
So the said suit was decreed. They said the TS 47 of 2009 was decreed in favor of the applicant, declaring his right, title, and interest, and also for delivery of first possession of the land
There is a counterclaim. also.
And dismissing the counterclaim of the.
by
Appellate.
dismissing the counterclaim. Full stop. The appeal referred against the appeal being TA 1 of 2021 referred against the judgment and decree dated 11/4/2019 was also dismissed. And accordingly, the connected second appeal under section 100 of the CBC was preferred. Next paragraph. The learned senior counsel for the applicant has submitted that in this interlocutory application, the applicant has annexed photographs of the part of the suit land where the respondents are carrying out, the public appellants are carrying out construction. So we submitted that it would change the nature and character of the suit land and therefore it pays for an ad interim injunction, restraining the respondents within bracket, appellants in the connected RSA 1 of 2016 from carrying out the constructions or to change the nature and character of the suit land. Next paragraph. Issue notice on this interlocutory application, returnable on so and so. Give a date after 2 weeks. 2 weeks is enough? No. Return in 2 weeks. Without requiring any first steps to be taken, as the respondents have already appeared. Next paragraph. The learned counsel for the appellant, for the respondents, within bracket appellants in RSA 1 of 2016, has submitted that as per her instructions. The respondents are ready and willing to hand over the house and all structures which have been constructed over the suit land. In the event the appeal preferred by the respondents is dismissed. She pays for and is granted 2 weeks time to file and undertaking from the respondents to that effect, if so advised. Next paragraph. In the meanwhile, having noted that the suit was decreed and the appeal preferred against the decree was dismissed, till the next date of this, the respondents, in bracket appearance in RSA 1 of 2026, are restrained from carrying out any further construction over any part of the suit land. Full stop. Full stop. The status quo as regards the constructions as on 27 type 26 shall be maintained till the next date of listing. Next paragraph, as the respondents are represented, the service of the copy of the order on the respondents is dispensed with. Accordingly, the instructing counsel for the respondents shall transmit a downloaded copy of this order to the respondents within bracket appellants in RSA 1 of 2026. At the mobile number of the respondent number 1, give it dash 950-87-16332, which is available at in the affidavit filed by the respondent in support of IA Civil 58 of 2026. Next list on, so give a date after 2 weeks. I have to rise. I cannot take up any other matter.
The order to be consumed.
Any interim order, please tell the.
Lordship, it is not possible. Very frequently is taking date matter. They are having said.
We don't know, this thing will be the discussion of the court master, because I can't give a date right now, I can look at my calendar right now. So, that's it, because I have a meeting with the, a meeting right now through video conferencing, it's an important meeting, I have to rise. And
Item 43 in order column,
Just
after
give it to
filing
him.
after filing the RSA lordship, the respondent died. So I have filed two IAs for substitution. If your lordship take up these two matters only, then I can file amended cost.
I can't do it right now, because there is a meeting at 4:30, that can't be postponed.
Item 40.
Just tell the court master. Just tell
Public.
I have, really have no time today.
Yes, Lord.
The meeting to be chaired by the Honorable the Chief Justice of India, and therefore I can't be late. Absolutely.